how could you have given effect to these recommendations by executive order under the 93 Act, that too, throwing the 2012 Act completely to sea without having repealed it? This is what is bothering us. Unless you explain this.
No, I have
all that we want to know, Mr. Dotto, for today's proceedings.
Milord, may I say this, Milord? I have answers to all the queries of the court. I am going to demonstrate that also.
Just demonstrate this for the purpose, because otherwise, ex facie, what appears to us is the 4 or 5 notifications that you have issued is in direct violation of our judgment.
No. No, Milord, so far as the commission's actions are concerned, Mr. Mozumdar had made his submissions yesterday. Now, your lordship desires to hear me on behalf of the state as to what actions the state has taken, Milord, post delivery of the judgment of this honorable court, and pursuing to, Milord, whatever actions have been taken by the commission, West Bengal Commission. Now, Milord, I have my submissions to make to justify the actions of the state, but as I stated yesterday, today also, Milord, I start by saying that the matter is pending whole hog before the Supreme Court. Therefore, Milord, we should await the decision of the Supreme Court. But I, Milord, will make independent submissions on the desire of the court to hear the state. First is, Milord, and I would end by also saying, Milord, that kindly, Milord, let us all await, Milord, the Supreme Court's decision.
Why haven't you awaited the decision of the Supreme Court?
No, Milord, we had informed the Supreme Court.
Informed the Supreme Court that you will conduct a fresh survey?
Yes.
Did you inform the Supreme Court that you will also issue notifications on the basis,
no, because
of the fresh survey?
Milord, please have a look to the order of the Supreme Court, Milord, which is at page 47 of the AO of the commission.
Yes.
AO of the commission?
Yes.
Only one.
47, Mr. Dotto?
Yes, Milord. It starts at page 45.
Effectively 47.
Yeah, 47. But here, Milord, the petitioner was the state. Mr. Sibbal Laret, senior counsel appearing for the petitioners, submits that the West Bengal Commission for Backward Classes is undertaking an exercise of examining the issue afresh that will likely to take further 3 weeks' time, list the matter in July on a non-miscellaneous day. Needness to state that the said exercise will be without prejudice, etc. Therefore, the entire exercise, Milord, what is required to be done post cancellation of those lists. Milord, we had informed the Supreme Court, and therefore, Milord, the matter proceeded. And Milord, the Supreme Court felt that, or Milord permitted us to, Milord, continue with the exercise, of course, Milord, without keeping, Milord, the matter intact. Well, without, yes. Now, it was between the same parties. Therefore, Milord, I personally feel, subject to your lordship's consideration, that whether the procedure which has been adopted by us is faulty or not, may not be gone into at this stage, subject to, Milord, whatever the directions are passed by the Honorable Supreme Court. But I am, of course, Milord, ready to, Milord, address your lordship on the issues that your lordships want me to address this court.
So, Mr. Dotto, you don't take further steps. We will await the decision.
But now, Milord, why, Milord? According to the petitioners, there is an electrifying speed at which I am proceeding. This is what they see.
No, you yourself said just
because,
now that the Supreme Court is in ceasing of the entire issue.
The entire exercise. Well, we have said the entire exercise. The Supreme Court was not told that we will do this and no further.
No, you have read out the order.
Yes.
Where you have told the Supreme Court that the Commission for Backward Classes is undertaking an exercise for examining.
Right.
The exercise, whatever has been undertaken, will either be tested by the Supreme Court or by us.
Yes.
Now, based on this, you did not tell the Supreme Court that you were going to issue notifications on that basis.
Milord, there are two ways of looking at it. One is, Milord, the Supreme Court may take umbrage of whatever we are doing today on the lines as your lordships are Milord, thinking aloud.
But by that time, third-party rights will be.
Yes. Now, Milord, what is happening is, your third-party rights are being affected by way of these petitions without the third parties being brought on record, number one. And number two is, my learned friends have not told the court the cause of which class are they espousing over here. Whose cause are they espousing? 4 or 5%? Milord, the allegation is that I am intending to favor somebody. Very well. Very well. Take it as correct for the time being. But which class are they representing? And which is that class which cannot come to this court because of poverty, XYZ, disability? But please look into the definition of our rules of public interest.
Milord, that we have dealt with in our...
Yes, today, Milord, I can understand, Milord, in that proceeding, Milord, that question was not gone into. But today, my lord, I think otherwise it becomes a personal interest litigation, publicity interest litigation. Your lordships have held that. Who is this Amol Chandra Das?
That the Supreme Court will decide.
No,
Mr.
in this proceeding, because today I would very respectfully submit, my lord, a public interest cannot be a personal cause for one person to keep on filing litigations at every stages. Please consider this, my lord, also. And very, very importantly, when, my lord, the exercise was undertaken by the commission, and your lordships were pleased to also ensure that people who want to object can object and go for and participate in the hearings. And that is why, my lord, in the contempt jurisdiction, your lordships were pleased to, my lord, pass orders balancing the rights of all the parties so that advertisements are made known to the persons. Whoever wanted to object can go and object. Now, these people, they don't go and object. And, my lord, all, my lord, activities are in court. All acrobatics in court. Now, please look into, my lord, what is the definition of public interest?
That was a bit harsh, Mr. Dotto.
Yes, yes,
Mr. Dotto, there is a problem in the sense that this issue of maintainability can't be re-agitated before us. You can agitate that.
So this is new petition, new cause of action.
Petition.
Yes, yes, yes.
Now on the same lines as the earlier one, and we have in substance decided maintainability because it was argued in extensio by you and
No,
replied to me.
please look into the last line of your lordship's order of 6th of May.
Yes,
Please have a look to that at page 43 of.
yes, please.
I'll just read for it.
Please.
The maintainability of the writ petitions is kept open on all counts.
Right.
Right. Therefore, now kindly look into our rules. But he has to come and say that X is the community who cannot come to court. I am a benevolent, magnanimous person. Therefore, I take up their cause. I espouse their cause and coming before the court. Because my rules are required, or this court's rule, as your lordships know, my lord, these rules were framed under orders of the Supreme Court. Because the Supreme Court felt that each and every high court, they were making their own way
Mr.
of
Dotto,
approach.
we need not go into that question at this stage. We have consciously kept the point open. We are asking you that whether you will stay your hands till the Supreme Court decision or you want a finding in Ingrita.
Millard, Millard, I have got.
We are also asking you,
Yes.
because as you yesterday also you submitted that don't interfere in this because Supreme Court is in CC.
Yes.
By the order of 6th May itself, a procedure was prescribed. Mr. Mojumdar told us what steps they have taken.
Right.
But the final decision is yet to be taken. In the midst thereof, the executive instructions have come. So today you don't give effect to those instructions till the Supreme Court decides. Finished.
Millard, the difficulty are manifold. Number one is, Millard, how do I carry out the admission process?
Take the 66 classes who are there.
Millard, tomorrow, please consider tomorrow. Millard, after say the admissions are over in the next month, take an example. Millard, your lordships validates our action. Then the persons for, the classes of.
That my brother has told yesterday. That
There is a chance.
Special recruitment drives, special admission drives are done on a regular basis in this country.
That is why, Millard, your lordships were pleased to, Millard, observe in the previous order that those who have got the benefit, they should not be disturbed, or the benefits.
That's right.
Yes.
Now they have
Therefore-
got this benefit for 15 years. We would like to ask the commission as to why, what benefit, what were the parameters set? Especially what benefit, how has their life improved in the past 15 years? In the context of section 10 of the 93 Act, where you are supposed to review it every 10 years or every period, which has never been done, unfortunately. We assume that this OBC benefit conferred on these classes, good, bad, indifferent, struck down by us, must have benefited them in one form or the other.
Yes,
That
Millard,
aspect has, whether that has been considered or factored in by the commission, we'll have to look into that. Now, the commission will answer it. We
right,
will.
right.
Now, insofar as your first argument is concerned, with regard to the rules of this court on PILs, we have ourselves in our order dealt with that and have recommended amendment of the rules based on a decision of the Supreme Court.
Right.
Because our definition was inappropriate in the light of the observations the Supreme Court made in that case. That is one side of it. We want to only ask you today, not the commission. Today we want to ask you, when we have specifically told, ordered and mandated in a judgment that your actions of a parallel power being conferred on the state executive and the legislature at the same time is unsustainable in law. And we have said that the expression state must be read as the state in exercise of legislative function. How could you have given effect to these recommendations by executive order under the 93 Act, that too, throwing the 2012 Act completely to sea without having repealed it? This is what is bothering us.
Very well, very well.
Unless you explain this,
No, no, I have
this is
no.
all that we want to know, Mr. Datto, for today's proceedings.
Milord, may I say this, Milord? I have answers to all the queries of the court. I am going to demonstrate that also.
Just
But
demonstrate
yes.
this for the purpose, because otherwise, ex facie, what appears to us is the 4 or 5 notifications that you have issued is in direct violation of our
No,
judgment.
no, no, no.